Hi everyone and good morning. My name is Noor Maki. I am the Senior Legal Counsel for Ford Motor Companies. I handle Middle East, everything legal in the Middle East. I'm joined by my esteemed panels, Astrid and Antonius. Welcome everyone. Okay, so we'll be talking about data privacy, a hot topic these days, especially in this region. So as data continues to play a vital role in our digital world, the protection of data privacy is becoming increasingly important. With data breaches and cyber attacks on the rise, consumers and businesses alike have become more concerned about how their private information is being handled and protected. As a result, cross-border data protection is emerging as a critical issue in the future of data privacy. So cross-border protection refers to the ability to maintain privacy and security protections for personal information as it is transferred across national borders. This can be very challenging due to the different laws and regulations between the countries, as well as varying levels of enforcement and compliance. To address this issue, many jurisdictions have put in place regulations governing the transfer of personal data across international borders. For example, in the EU, the GDPR imposes very strict rules for the transfer of personal data outside of the EU. Similarly, the newly enacted California Consumer Privacy Act requires businesses to disclose their data practices and allow consumers to opt out of the sale of their personal data. However, many experts believe that more needs to be done to ensure the effective protection of cross-border data privacy. This may include the development of harmonized international standards and greater cooperation between different jurisdictions to ensure consistent practices, consistent protection across the borders. So I'm going to open up to my panel speakers with the discussion by asking the first question here. What are the challenges in cross-border data flows? Astrid, over to you.
Thanks, Noor. So I think, if you as a global company, or just as any other company, if you transfer data cross-border, you need to take into account the local jurisdiction requirements with respect to the processing of that data. Now, if you are a global company, you may have to face different jurisdictions with specific requirements regarding the processing of personal data. So each and every time when you decide to actually transfer the data that you process from country A to country B, you need to consider what are the requirements. Am I allowed to do that? And if so, under which circumstances am I allowed to do so? And the more jurisdictions you operate in, the more complex the world becomes for you. Also, when it comes to the interaction of these jurisdictions with each other. So those could be really some challenges. And what we have seen lately also is the trend of data localization, which may also bring some huge challenges for companies where you are required to actually localize the data in under a certain privacy framework.
The data localization is clearly presenting an issue here. I'll give you an example with what we're facing currently at Ford. So we're bringing in eCall, which is a legal requirement to have the emergency call in vehicles at the moment. So as an American company, the cloud is obviously not stored here. It's stored in the US. But now the Cybersecurity Council, working with Etisalat, has enforced us to keep the data, to keep everything localized, which is obviously not possible. We don't have the infrastructure. But now they're basically imposing us to build this infrastructure locally across the regions where this data will be transferred. So how does this cross-border data transfer work under GDPR?
So if you look at the GDPR, you have a few possibilities under which you can actually transfer the data. So to name a few, so one is that the European Data Protection Board, the EDPB, has provided a so-called adequacy decision. Basically, it says that the countries on this list, we call it a white list, those are the countries that are safe to transfer data through. So that is one option. Now, if the country to which you want to transfer the data to from Europe to another country is not on that whitelist, then you have another option, which is you have to conclude contractual safeguards. Now, the European Commission has provided some standard contractual clauses which you can use to make sure that when you transfer the data cross-border, the processing of that data in that country is processed under those conditions set out in those standard contractual clauses, which then will provide an adequate safeguard to the individuals involved. Of course, consent is also one of the grounds that you can use to transfer the data cross-border, but consent can be withdrawn. You need to make sure that you collect the consent in a valid way. So you need to manage the consent. So it involves a lot of operational work if you work with consent. Therefore, many companies try to avoid working with consent. So I think, if it's not whitelisted, most of the companies use the standard contractual clauses. So you need to make sure that you have the right contracts in place with the vendors to which you are actually transferring the data to.
Thank you. Antonius, so you work in the APAC region. Considering the territorial scope of GDPR implies that despite your location in APAC, because you're still offering services from the EA, do the companies have to still follow GPDR regulations?
Okay, well, there is an interesting question, Noor. And also I'm happy to be here because after the pandemic, we can stay together without the mask. But don't worry, I already vaccinated all of the vaccine brand in my body, so it's safe. So back to your question, Noor. Yeah, I work for the telecom company that offer the service and goods to the European, because when they become the customers of my services and they bring the SIM card to their home countries and they still use it, the SIM card to communicate with their relative and their colleagues, they still we still as operator we still monitor the movement of our customers within the Europeans. So on that logic, meaning that under the GDPR, we are obliged to follow the GDPR, because under the Article 3 of the GDPR, when you are established in the EU or you are offering goods or service in the EU. So knowing that the service of the communications like telephone or the technology service at the moment now become borderless. The customer can go over the world, they can return to their home country. So in that aspect, we can say that the GDPR can imply despite their geographical location. Furthermore, it can be a challenge as well for the GDPR, because in my perspective and also I did my PhD thesis about the data privacy as well. The GDPR facing challenges to enforce the law outside the European regions, because there is no something great that the other country can follow the GDPRs. For example, in the Asian region or the Latin America, they want to follow it, but if they violate the GDPR, so what? That is the problem at the moment. There is no legal enforce, the real legal enforce from the authority of the GDPR. However, if we talk about in the APEC, actually in the Asian Pacific, we already have the mutual framework. We call it the APEC Privacy Framework since 2005. So the Asian Pacific economic countries have the mutual understanding related to the privacy to how we technically govern the privacy between the countries to support the transborder data, the transborder the personal data of the customer within the Asian Pacific economic countries. That is the aspirational method, and between the countries still encouraged to have the bilateral or multilateral cooperation to make it the real implementation between their countries. That is the situation at the moment, Noor.
Thank you, Antonius. Astrid, another question for you. Let's talk a little bit about Privacy Shield. What is it and why is this only with the States?
Yeah, so Privacy Shield is basically a set of rules which is applicable to data transfers that happen between the European Union and America. So I just explained to you in the beginning about that whitelist. Remember the EDPP had made, well, US is not on that list. So what they came up with in the past is to implement a safe harbor principle, which means that, which meant that, you know, if that was an organization in the US which basically gave companies a certification. Once you had one of those certifications, you were considered as a safe harbor company, and therefore then it was safe for you as a company from the EU to transfer data to the US. And all of this happened, you know, because they wanted to enhance the economy and the business between EU and the US. So, and then there was Mr. Schrems, who started a litigation stating that actually his data from Europe was being transferred to the US, where it was not safe because of you know, the Snowden effect and the Patriot Act. And so with that, the court in the EU decided that indeed the personal data of individuals in the EU is not safe enough in the US. So they came up with another privacy framework called Safe Harbor 2. Well, Mr. Schrems went again to court, and again he won the case, and the judge stated that Safe Harbor 2 was also not valid. Now finally we have a third privacy framework, which is called the Privacy Shield. So everyone is hoping actually that this one will work. But that will then eventually depend on what the judge will decide if Mr. Schrems decide to initiate a litigation again. So that's the reason why it's only with the US. It's just to ensure that there's a safeguarded data flow from the EU, from EU citizens to the US.
Okay, thank you. Let's bring this conversation closer to home. How does cross-data transfer look under the UAE federal privacy laws?
So if you look at the UAE federal privacy law, which has not kicked in yet because we are all waiting for the executive regulations, it is quite similar to the rules under the GDPR. So there's no data localization requirement, thank God. And so you have different options like the safeguard, the whitelist, you know, the contractual clauses, similar to GDPR under the UAE federal privacy law. And if you look at the privacy law in Saudi, the first draft privacy law in Saudi, that one had a data localization requirement, but thank God there has been a change in that. So I think it was March 18 when they published the new executive regulations, in where actually it is stated that under certain conditions, you are allowed to transfer data cross-border. So they loosened up on the data localization requirement, which is, I think, a good thing. It will enter into force on the 14th of September this year, and everyone has 1 year to comply with the law. So by 14 September of 2024, we have to be compliant.
Antonius, what do you think? How can technology provide a solution in ensuring cross-data protection?
Well, I think it is the imperative role that the technology can help to protect the personal data of the customers. For example, several vendors of or the third party, they provide the particular strategy or method. We call it pseudonymization or de-identifications of the customer of the personal data. So I think it is a good products and potential products that can offer to the several organizations in order to help them to secure the personal data of their customers. But please note that the tools we can say that the governance related to the personal data tools is not automatically you already govern with the local laws and regulation related to personal data. It is the tools to help you to protect, to enhance the level of protection of the personal data. And it is mandatory, in my point of view, for the modern organizations, particularly for the multinational company that operates in the different level on the different areas of jurisdictions. They have a different laws and regulations that have to be aware of. So they have to be helped by the third party and vendors how the privacy enhanced technology to help secure the personal data. And for sure, we know that about the if we talk about for example, the data localization that Astrid already mentions, the aspect that we have to consider about the data localization is the sovereignty of the personal information within the country. For example, why the countries eager to implement the data localization in their regulatory framework? Because they want to secure the information, particularly for the strategic and sensitive information, be it their president, be it prime minister, be it on the specific strategic like the military. They want to protect the information just in those countries, not to the outside of country. So the sovereignty of informations we can understand about the aspect we want to save, right? Our country want to save. However, the nature of the technology at the moment, we need the collaboration. Still, the personal of data should be in the first seat of our program, not in the back seat or the second seat. It is the first priority. However, how we can protect it, the individual not to expose their sensitive informations. So we support the collaboration between the countries. On the other hand, the business still flourish.
Okay, so in Saudi Arabia, we were told there's a data privacy law. And then we were told the deadline for complying has been postponed. And then we were told there's going to be an amendment and a revised version of this law. So, Astrid, what are we expecting to see now from this revised version?
Yeah, so it will enter into force on the 14th of September this year. The text is only available in Arabic. There's no English official translation yet. But yeah, you can come far away with Google Translate. And yeah, so everyone needs to be compliant on the 14th of 2024, 14th September.
Everyone.
Yeah.
Write it in your diaries.
Yeah. So when I think, now that Saudi has come up with the regulations, I think UAE will also soon come up with the regulations. What's also very interesting to mention, I think, is that India is also on the move. You know, they have had some different draft privacy bills, and our guess is that in July this year they will come up with a new digital privacy bill, which will enter into force, which is quite similar to GDPR, also having this extraterritorial effect, Antonius, you're talking about. And they also talk about the white list, the list of countries to which it is safe to transfer data to. So there's no data localization requirement there in India, but we do have to consider that list, which is an extra challenge for companies working globally. For example, VFS Global, we operate in more than 160 jurisdictions, so we have a lot of jurisdictions to take into account. And I think, you know, if you look at what are the options, right, for you as a company to not to be bothered every time by all these requirements locally and make sure that you are compliant. So one of the mechanisms that you could use is, for example, the binding corporate rules, which is provided under the GDPR, which is basically a set of rules blessed by one of the authorities, supervising authorities in Europe, and which you then implement within your company and make sure it's applicable in all those jurisdictions, where you just go for the most stringent jurisdiction and apply that as the maximum, the highest level of protection to the processing of the personal data of your clients and individuals. So I think, you know, that is really a mechanism that global companies should explore more and more. What I think it's not really good is that, like Antonius, you mentioned, we should actually have some kind of a global privacy framework, right? Where which makes our lives much more easier. Not there yet.
So I have had a chance to quickly skim through the Saudi amended regulations in Arabic. What is so pleasing to know is that now transfer outside territory is being relaxed. So the original version said there will be no transfer of data outside the kingdom, which is obviously a huge problem, especially for multinational companies, where this transfer has to happen in order to basically operate internationally. So the revised version does point out that this will be relaxed. There are exceptions. They can be transferred subject to certain conditions being met. So we do look forward to seeing when the English one becomes available. Antonius, any more comments from you?
Yeah, I think the future of data privacy will be bright, particularly for the professions related to the data privacy. We have the data protection officers at the moment. It is the new professions. We can see on the last decade there is no data protection officer, but now they exist. I think it is the opportunity for us to expand our career, and also the opportunity for us to expand our business related to data protection officers. And the understanding between the countries related to the data protection should be, I think, deeper, meaning that, for example, when I work, I have a work in London, but for the short time. But I returned to my home country in Indonesia to help my companies. But I think I'm not really. I think it's not important to study GDPR, but I was wrong. I have to study the GDPR because of the borderless nature of the technology. I also have to study the personal data protections regulation in other Asian countries in APAC. For example, for the New Zealand with the Privacy Act 1993, with the Singapore, they have the Personal Data Protection Act. with the authority, with the personal data protection commission in Singapore. I also have to look into the several regions in order to perform in my daily work. So yeah, the future of privacy will be bullish in the next decade because technology is evolving. Privacy is the basic needs of the customers, as already written on our UN Declaration of Human Rights. Right, so it is the fundamental values of the humans. So it will be bullish in terms of the opportunity for growth in the data privacy sectors.